Hey, what's going on? Good morning. This is Will Farrell of Fed Employees Fight EEO Abuses. Our primary communication interface location is over on Facebook. Welcome to join us if you're already here. Hey, if you know people that are suffering, federal employees that are suffering through EEO abuses, invite them to join. Our community is here to support each other, empower each other, share notes, share comments, share information to help each other get through this very stressful, very trying, and quite often abusive process. Got a few other, I've been reading a lot of my claims numbers for my complaint. I'm at the reconsideration phase, which is the very last thing I can do while in the EEOC realm. My options after this, if this is refused, then I can head on out to circuit court, which I'm kind of thrilled. I'm kind of challenged to give it a shot. It's taken me 6 years to learn this EEOC process, and at the reconsideration phase, I've been dunked for my regular ruling, which I appealed, was dunked again. In the reconsideration, you can ask the EEOC Commission based on very strict criteria to reconsider the ruling, right? So I've read a lot of my prior claims. I got a few more. There's 18 claim complaint. And it's really an indication of the repeated ongoing abuse, harassment, hostile work environment, and intimidation and bullying that they, kept doing and kept going. But the problem is that the courts look at it as long, tedious, and a waste of their time. They don't look at it. You and I, we're the victims, and we want justice. So hat for them. They pay that no mind. So I just want to go over a claim or item K. This is not a particular claim number. It's a procedural issue that the judge did wrong. And I need to articulate the judge's actions to a law or requirement to cite that it was erroneous interpretation. That's a tricky, dicey thing to do. A lot of times in this phase, we want to keep arguing what they done wrong. And you may be totally 100% right. You may get 100 out of 100 people say, yeah, she's right, they done it wrong. Here's the question. Can you provide your evidence, map that to the laws, and then you need to cite the court cases where those precedents were upheld. Even if you have an attorney, many attorneys aren't that thorough or detailed. As a matter of fact, even if you have an attorney, you need to work with your attorney. You need to be a partner with your attorney. An attorney won't pay you no mind if you haven't done your studying, if you haven't done your homework, your preparation. They treat you like a kid. You'll be arguing about what you know injustice has been done, and they'll just brush you off. All right, so item K. The AJ's decision involved a clearly erroneous interpretation of material fact and or Petty versus Department of Defense, EEOC Appeal Blah, CFR 29-1614.405A, see Universal Camera Corps versus National Labor Relations, and Singh versus George Washington University, and Lemons versus Georgetown University. Oh, I repeat, and CF 29 CFR 1614.405A. Now, again, what I did right there is one of the requirements for requesting a reconsideration is you have to evidence that the AJ's decision involved a clearly erroneous interpretation of material fact, and you have to understand what an material fact is, or law. So what I did was just cited all the laws. All right. I'll continue. When she improperly failed to ensure that the record was ready for summary judgment. What? In the July 29, 2020 order entering judgment at page 4, the AJ ruled stating, complainant has satisfied the procedural prerequisites for a hearing, But because there are no genuine issues of material fact or credibility, the evidence does not warrant one. And she said the parties had the opportunity to engage in discovery. So with that statement right there, she gave me a lot of kudos. She says, hey, the complainant has satisfied the procedural requirements for a hearing. So which says that I've proved all my prima facie requirements. That's a very powerful statement. I don't have to keep arguing about my prima facie statement. She already said he got it. But then she says, oh, but there's no genuine issues of material fact or credibility, which means that there was none in dispute, and therefore she can rule in favor of the agency's motion. They had the stronger evidence. All right, so I continue. The March 2nd, 2022 decision remains silent. All right. The record reflects that. I go on to name a document that was in the file. Agency plus digital plus file plus submission plus Pharrell plus appeal plus number, blah, blah, blah. Section 9, page 754. You have to be specific. If you're going to say something, you better point to where it is. Don't leave it them to find it. They won't find it. I trust you. Even when you point it, they despise finding it. So this particular document that's uploaded means it's the record. It's the record that was for that particular decision, the March 2nd decision. So that's all that was at that section on page 1754. It reflects that the June 13th, 2019 claimants for motion for summary judgment, dismissal, denial used the term agency's response to discovery requests, specifically referencing data in the agency's response to discovery requests approximately 22 times. So in that particular motion, the claimant, me, referenced the agency's response to discovery requests 22 times. I did discovery. I needed to add what I found in discovery to the record. That's the reason why you do discovery, right? For example, the agency admits that the PPMD currently does not employ any African-American male managers at a GS-14 grade level or above. Agency's response to discovery request, page 18. And the agency admits that this position, the GS-14 CSAM manager, was never offered to the complainant. Admits that PPMD currently does not employ any African-American male managers at the GS-14 grade level or above. See agency's response to discovery request, page 19. And the agency admits that the position was previously filled by Davine Barton at the GS-14 pay grade, was filled laterally, moving another GS-14, Jeff Moreau, into that position. The agency admits that this position was never offered to the complainant. See page 14. And admits that PPMD currently does not play. So I repeated that a couple times, right? But both of the prior decisions improperly failed to cite, recognize, include, weigh, or rule on the material facts and substantial evidence. Those are material facts. They don't employ these people of my demographic at the GS-14 level. It's a material fact. That job was a GS-14. Material fact. It was not offered to me. Material fact. We need to find out why. The guy who got it wasn't my demographic, and he had no experience on that CSAM manager. Yet I've been doing the job for over a year, acting in the role of the previous official manager. Why was it not offered? These are material facts that need to be weighed out and tried in a trial. I'll continue. Substantial evidence is defined as such relevant evidence as a reasonable mind might accept as adequate to support a conclusion pursuant to 29 CFR 1614.405A. See Universal Camera Corps and National Labor Boards. A material fact. A fact is material if it has the potential to affect the outcome of the case. So what I just read you, were they material? Were they substantial? You make the call. According to the Supreme Court, Rule 56 itself precludes summary judgment where the party opposing summary judgment has not had the opportunity to discover information that is essential to his opposition. Anderson, 477 U.S. at 205, the complainant did in fact perform discovery, but the record reflects that the discovery was omitted from the record. The AJ erred in ruling on the agency's motion for summary judgment. A court's function is not to weigh the evidence, but rather determine whether there are genuine issues for trial. And I cite, ID at 249. The evidence of the non-moving party must be believed at summary judgment stage, and all justifiable inferences must be drawn in the non-moving parties. And I reference section 255. An issue of fact is genuine if the evidence is such that a reasonable fact finder could find in favor of the non-moving party. See Celotex versus Catrix and Oliver versus Digital Core. By ruling without including the discovery documentation, the AJ acted improperly when she failed to determine that the record had been adequately developed for summary disposition. See Petty versus Department of Defense. A closer examination of the record fails to verify that the agency ever uploaded the agency's response to discovery request, and the AJ never inquired about the missing or incomplete documents and its including material facts in either of her rulings. Furthermore, the facts presented in the agency's response to discovery request are clearly adverse to the complainant and are strong indicators of retaliation. See EEOC Compliance Manual, Section 8, Retaliation. Also see Simons versus Department of Justice and McMillan versus U.S. Postal Service and Whitmer versus Department of Air Force and Bright versus Galley Accounting. If not, discrimination and harassment / hostile work environment claims are particularly susceptible. See Meany versus Department of Treasury, Drake versus Department of Air Force. A materially adverse action for purpose of retaliation claim is not the same as an adverse employment action required to bring discrimination claim. Rather, it is an action that could well dissuade a reasonable worker from making or supporting a charge of discrimination. So with that saying, about a judge throwing away my whole discovery, how can she even rule on retaliation or reprisal or hostile work environment? She trashed the evidence. She dismissed it without even ruling, without commenting. Just let it disappear, slip through the cracks, evaporate, eviscerate, all by itself. The complainant was aggrieved by the oversight, and I'll continue, The complainant was aggrieved by the oversight and omission of his discovery responses from the EEOC ruling on July 29, 2020 and March 2022, indicating that the Appeal Commission failed to observe, cite, and rule de novo pursuant to 29 CFR 1614-405A, stating that a decision on appeal from the agency's final decision shall be based on de novo review. See Equal Employment Opportunity Management Directive 29 CFR Part 1614 EEO MD 110 of Chapter 9, revised August 5, 2009, providing that administrative judge's determination to issue a decision without a hearing and the decision itself will both be reviewed de novo. All right, so that's just saying de novo. Hey, if the first judge missed my discovery, how in the world by coincidence did the second judge just coincidentally also miss my discovery when both are required to rule based on everything that's in the record? I continue. Injustice will result if reconsideration is refused. I didn't make that up. This comes directly out of court case. That is, the movement demonstrates that some harm, legal, at least tangible, such as him not being able to prove his claims. The agency will continue to systemically discriminate, retaliate, and harass victims with assurances that the EEOC will be so overloaded that they will look the other way, and complainants would not be able to rely on the integrity and compliance of the EEOC Appeals Commission would flow from a denial of consideration. That's from the Cobell Court and the Bank Julius ruling, quoting the FBME Bank versus Nuchin. Even if the appropriate legal standard does not indicate that reconsideration is warranted, the court may nevertheless elect to grant a motion for reconsideration if there are other good reasons for doing so. Again, I didn't make that up. That comes straight out the book right there, a case court ruling. The complainant reminds the court that a pro se complaint, however inartfully pleaded, must be held to less stringent principles cited than formal pleadings drafted by lawyers. That comes out of Abdullah Fattah versus U.S. Department of Homeland Defense, quoting Erickson versus Pardon. Now that's a very interesting court ruling. For you guys who are pro se complainants, man, we have next to nil chance of winning. The loss ratio with and without lawyers is approximately 98% for us complainants. Pro se, it drops down even less. But you see right here, this ruling says that judges are holding us to a standard when they should be extending us some grace. That's all it is. Say, hey, you got to extend some grace, a bell curve. They're not lawyers. We don't get that. I'll continue. The complainant petitions the commission to reverse the summary judgment ruling, then review it de novo, including the facts presented in this petition and agency's response to discovery requests and the complainant's timely and compliantly submitted June 13th complainant's motion for summary judgment, dismissal denial, with its statement of undisputed material facts on pages 8 through 14. View the evidence on the record most favorable to the non-movement and award summary judgment to the complainant for claim number 18 why did I say claim 18? That was an error. With punitive and compensatory award or remand the complaint for a hearing. All right. So, sometimes you hear a lot of people whining and crying about the EEOC process, and it's very hard to articulate it. The whole process is very, very difficult, but it's extremely hard to articulate it. Seeing some errors without seeing some errors. Hard to articulate without sounding like a crybaby or just sour grapes, right? And so that I just wanted to read some of the injustices that were executed and give you a chance to hear in real time the facts and the actions that were taken versus what the law says was supposed to have happened. All right, hey, thanks. Good luck. Reach out if you're a federal employee. Reach out to us on Facebook channel. Hey, if you're not a federal employee, it's not about discriminating against you. It's just that federal work environment has slightly different rules and requirements, and we can help you a little better in that area. All right, good luck. Keep fighting. Whatever you do, don't quit. Reach out, get help. Thank you. Bye-bye.